Hello, everyone. My name is Daniel Malin. I'll be moderating today. Thank you all for joining us. We'll be starting in just a couple of minutes as people roll in. Hello, everyone. We'll be starting in just a minute. Just waiting for the final guest to join in. All right, great. Good afternoon, everyone, and thank you all for being here and tuning into the CLE course number 6703, Practical Tips for Litigating Blockchain Issues. This is the second installment in the Florida Bar Business Law Section's Blockchain and Digital Assets CLE series. My name is Daniel Malin. I am a complex commercial litigator, and I also advise companies in the Web 3.0 space in Miami at the firm Renner, Vogel, Mandler, and Rodriguez. And I have the pleasure of serving as chair of the CLE series. We appreciate your spending your time with us today as we delve into our first practical explanation for litigators and anyone else who might be interested in how to litigate blockchain issues. For those of you who would like a primer generally on blockchain technology, tokenization, and the foundational fundamentals of this tech, you simply need to go to youtube.com. I believe you've all probably heard of it, and search for the business law section courses 5776. And that's our course on blockchain and tokenization made simple. And you could also search for course 6078, tokenization explained. Both of those are CLEs, just as this, that are free. And at the end of those YouTube videos, there's going to be a CLE code that you can enter into the Florida Bar's website for credit. We will continue to have more panels approximately every 2 months, rolling through the next year, focusing on other topics such as transactional law, real estate, and other areas of interest. And at the end of this hour, this panel will be posted on YouTube as well. So please, if you like it, share it, let others know about it, and they also can take advantage of the free credit. And of course, if there are particular areas you would like to see a panel discussion on, let us know. We'd love to hear from you. And even better, come join us at one of the next business law section blockchain and digital asset committee meetings. We'd love to have you. We're always looking for more participants. With all that said, I'm extremely excited to moderate this panel discussion on practical tips for litigating blockchain issues. As I said before, we're not going to dig into the basics of what this tech is. We're actually going to talk about where the rubber meets the road. We'll be discussing real-world practical guidance on litigating these issues. And we have a chat feature on the bottom. It says Q&A, you can see that. And if time permits, and I'll do my best to ensure that it does, we'll be having a Q&A session with the panelists at the very end to discuss any questions you may have. Just leave those there, and we'll do our best to get to them. Now, to introduce our esteemed panel, I'd like to start with Judge Alan Fine, who is one of the 2 presiding complex business litigation judges in the 11th Judicial Circuit in and for Miami-Dade County. Judge Fine graduated from Princeton, magna cum laude, and from the University of Florida's Levin College of Law, cum laude, where he served as a member of the Law Review editorial board and was on the mock trial team. He then practiced in private practice for 28 years, focusing on international commercial litigation before being appointed to the circuit court in 2012. And he's since been re-elected multiple times. In addition to serving as a circuit court judge for the past 10 years, Judge Fine has served on the board of directors of the Children's Trust and served as the externship director for child welfare at Florida International University School of Law. And most impressive of all of these accolades is Judge Fine's present role as judicial chair to the Business Law Section's Blockchain and Digital Assets Committee, and we're lucky to have him.
Thank you.
Next, we have Ian Corp, who is a litigator with Agentis PLLC. Mr. Corp represents businesses and individuals in a broad range of commercial litigation matters, including commercial real estate, partnership disputes, fraud, and bankruptcy adversarial proceedings, All of those touch on crypto and blockchain. Mr. Corp also advises cryptocurrency and NFT projects, creators, builders, and governance, regulatory, and litigation matters. Ian frequently publishes articles on regulatory developments impacting digital assets and has been repeatedly quoted by various cryptocurrency publications, including Blockworks. I highly encourage all of you all to follow Ian on LinkedIn. It's IANCORP. You could read his name right there. He's really got his finger on the pulse and does a very impressive job of providing updates online. Really worth a follow.
Thanks, Ben.
In addition, we're joined by Ms. Melanie Damian, co-founder of the law firm Damian and Valori LLP. Ms. Damian is a past chair of the business law section of the Florida Bar, president of the International Women's Forum, Florida chapter, and served as co-chair of the IWF 2018 World Leadership Conference. Ms. Damian represents public and private companies and individuals in a variety of complex business and security litigation, and she regularly serves as a court-appointed federal equity receiver, special monitor and distribution agent, and also serves as a receiver and monitor in state court matters. Ms. Damian also serves as counsel to receivers serving both state and federal court, and she counsels companies on corporate governance matters as well, serving as counsel to special litigation committees performing internal investigations in response to shareholder derivative demands. She also represents officers and directors in corporate and securities litigation matters and various partners or members in closely held business divorce matters, and she's a perfect fit for this panel because of that. Finally, we have Robert King, a partner at Concept Law Group PA in Fort Lauderdale. Robert's practice focuses on computer law and related intellectual property rights. That is patent, trademark, copyright. He is IP board certified, current vice chair of the Florida Bar's Blockchain and Digital Assets Committee, and chair of the Florida Bar's UCC Article 12 Task Force, which will permit digital asset owners to use cryptocurrency and NFTs as collateral for loans. If you are lost by what I just said, I still encourage you to go to YouTube and check out the other videos that we have. You'll be up to speed in no time. His current interests include legal aspects of NFTs, blockchain systems, and artificial intelligence. He is co-author of Patients as Peers, blockchain-based EHR, which Nova Southeast Law Review published in 2020. He's a former chair of the Bar's Computer Law Committee and a member of the Business Law Section, the Legislative Committee, the IP Committee, and the Blockchain and Digital Assets Committee, as I said. And with that, Mr. King, I'd like to start with you. The famous Satoshi Nakamoto white paper putting forward the idea for Bitcoin came out in 2008. It's 14 years ago that the world has been dealing with this technology. By no means are blockchain and digital assets new technology, but they really seem to have caught the world's attention in earnest over the past 5 years. We've had the rise and collapse of the crypto bubble, the social explosion of NFTs, and again, if those words mean nothing to you, YouTube. And now the world's attention is drawn to FTX, and courts around the world are drawn into this monstrous collapse. However, blockchain and crypto litigation is not something that just arises out of fraud or bankruptcy, the topics du jour right now, nor is this technology fading away. To the contrary, major institutional players are leaning into the space even more. PayPal just announced that it has opened up its crypto services in Europe, and Goldman Sachs head of digital assets, I believe just this week, explained that FTX's collapse has only increased Goldman Sachs' likelihood of their getting more involved in the space. So I'm going to quote him. He said, "There are some really interesting opportunities priced much more sensibly," meaning these companies are buying in, they're not selling right now. Robert, as an IP attorney, deeply involved in this space, I'm hoping you could walk us through who the litigation specialists and what the specialties are that you think are going to be having an uptick with this ongoing trend towards blockchain and digital assets.
Thank you, Dan. Excuse me. I think we need to understand that cryptocurrency, although it is a blockchain, really the most recent interest over the past couple of years has been non-fungible tokens, NFTs. And so when you're dealing with an NFT, you have much more need for intellectual property counsel. The NFTs, non-fungible tokens, as an example, usually contain artwork or video clips. A good example is the NBA Hot Shots. So you need IP counsel to make sure that what you're buying, if you're buying the NFT coin for a hot shot, what intellectual property rights you have in the underlying work, and that triggers, of course, copyright, the right of displaying the work, whether you have public display rights, derivative, whether you can make a joke or a comic strip or put the NBA Top Shot short video clip to music. The other thing that impacts NFTs is how the NFT developer is actually indicating whether there's a secondary market for the sale of minted NFT tokens. Then you run into possibly Securities Exchange Commission issues about whether the NFT is operating as a security under the Howey in the Hills test. Ian Corporate can probably elucidate a little bit more on that. There's a possibility that the NFT token also operates as a commodity under the purview of the CFTC. Interestingly, the SEC and the CFTC has been engaged in a turf battle over the past 5 years, and neither agency has adequately claimed rights to it. Nonetheless, fraud is still fraud, and the SEC has the right to march in and claim that the NFT token is a security. The way it's marketed and the way the NFT developer has set up its interaction with the platform that's holding the NFT. Turning the attention to cryptocurrency, which is a very, very hot topic now with the collapse of FTX. Although that cryptocurrency is based upon blockchain, the issues regarding securities issues, as well as corporate issues, setting it up properly, and whether that cryptocurrency is a commodity is still an undecided issue in many of the courts. As to the last major aspect, not well known, but still available, is the DAO, a distributed autonomous organization, which is also a blockchain. General consensus is, well, let me explain a bit about the DAO. The DAO operates like a partnership without a CEO or an executive. So one way to establish the DAO and run the corporation is through obtaining 50% plus one vote of the owners of each, I guess, membership interest. General consensus, and again, Ian and Melanie might have a better view on this than I do, is that the DAO operates similar to a partnership. So when a client walks in, you as the skilled attorney really have to take some time, understand what the client is doing. Is it an NFT? Is it a utility token, which is a form of NFT? Is it cryptocurrency? Or is it a combination of all those items? I have had clients come in and map out a business plan as a combination. So you have to be careful and bring in those counsel. And if the client is reluctant to spend that amount of money, make sure you document that you have absolutely told them that they need SEC counsel or a skilled corporate counsel if you're an IP lawyer, and vice versa. If you're a corporate counsel, make sure that you document that maybe we need to talk to a technologist, a computer lawyer, or an IP lawyer.
Robert, do you think there's going to be some more regulatory clarity coming up in the near future as a result of President Biden's executive order on digital assets and also the FTX collapse? Do you think that's going to spark action from the regulatory agencies to come out with more firm positions to guide us?
Believe it or not, I don't think so. The reason is that the SEC and the CFTC have a difficult time in describing what cryptocurrency is. It's easier to describe an NFT because it's tied to usually some type of audio or audio-visual or video work. And I think that's the major problem. The biggest move recently is going to be the newly proposed Uniform Commission, the UCC Article 12, which permits lenders to secure their positions in cryptocurrency as well as NFTs. And I see that trend in a lot of the states having to do with regulating exchanges. Now, an exchange is where you keep your cryptocurrency because you need cryptocurrency to buy NFTs. And even that territory, from the federal standpoint, has been ceded to the states. Usually, the states require a money business license in the nature of like what Western Union has.
What's the time frame on the UCC modifications? Do you have any idea? I'm not asking you to give us a concrete answer, but as the head of the committee for the Florida Bar, what's the talk of the town?
Currently, it's on a fast track. Of course, there needs to be a Florida legislator who wants to introduce the legislation. It does impact about 5 sections of the UCC, and the task force I'm running is fairly in line with the fast track, but we'll see in the next 2 months, because the task force, if indeed the legislation is filed by the one of the senators, then the white paper from the business law section has to be complete. With a little bit of luck, we'll be able to get it done, but we do have to get the white paper cleared by about 3 substantive committees in the BLS.
There's work to do. Well, Ian, as a litigator in this space, if a client calls you up and they've got an issue pertaining to an NFT, digital assets, or some other blockchain related problem, what steps are you going to be taking to diligence this matter, understanding this ambiguous regulatory cloud that we're kind of in, and how do you put together your case plans following those calls?
So I'll actually give you an example of a consultation that I had a couple months ago, where a client came in and they said that they had purchased an insurance policy against the Luna and UST tokens, which, if you recall, back in May of 2022, this year, they fell apart and their values went to zero. The client purchased an insurance policy from a DAO, which is something that Robert mentioned earlier in this presentation. And they purchased that insurance policy in the event if the Luna token or the UST token crashed below a certain point, they would be insured for whatever Ethereum they invested in those tokens. And what we had asked from them initially was, what documents did you review from the DAO that you purchased it from? And give us a copy of the insurance policy as well. We asked for all wallet addresses, which is the fiat equivalent of that is a bank account. It's just a series of numbers and letters that tells you where cryptocurrency or NFTs are being held. We asked for transaction hashes when they purchased the Ethereum and invested that Ethereum into the DAO, as well as the insurance policy. Those hashes are simply transaction IDs. And we also asked for the block hashes, and that's the identification of the block space on the blockchain where the tokens were purchased. And we also asked for any terms of service that they might have received from either the DAO, the exchange, that they purchased the tokens from or the protocols to really identify who the entity would be. So the first step, that's the initial rundown of what I would ask the client for, is to really understand what information we have to work with, because unlike traditional securities, we don't have, for example, an investment prospectus most of the time. That the only functional equivalent we might have is a white paper that explains what a project or token does, but not necessarily what its investment risks are, whether there are conflicts of interest, things that you would normally see in a prospectus or an S1 filed with the SEC. And after getting all of that information, we'll then sit down with the client and understand, okay, who we have to identify first, who is the entity we're going after? Is it the protocol that sold the tokens or converted the tokens from one to another? Is it the DAO that ultimately sold the insurance policy? Is it the individuals and developers that are operating that DAO? So Robert touched on the topic earlier about how DAOs are general partnerships. Sometimes they are, sometimes they're not. Most individuals that are pursuing class actions against DAOs in today's day and age, they are asserting that theory, but that depends on the technical functions of the token itself. As Robert mentioned, some tokens are utility tokens, which grant you the ability to participate in the voting rights of the DAO. And those tokens might also be a cryptocurrency because they might have their own inherent value that you can trade on an exchange or convert with another currency for like value. But that doesn't necessarily mean that those tokens allow you to share in the profits of a DAO, which is the general test to establish a partnership between an unincorporated association of persons. So if those tokens don't give that ability, then you probably won't be able to call it a general partnership and then hold the rest of the token holders liable for it. So after identifying who the entity was here, that's what we did. We figured out that the entity is most likely going to be a DAO. And what we did is we looked at the insurance policy, which unsurprisingly was not an extensive document like you probably received from your auto or home insurance carrier. It was a 4-page document that said, if X happens, you're entitled to Y. That's it, no exclusions or anything of the like. What was interesting is that it included an arbitration panel, an on-chain arbitration panel known as Claros. And these clients had already told us that they had submitted their dispute to the Claros arbitration panel, which is, at least for what they advertised, a disinterested, unbiased arbitration tribunal where their claims could be adjudicated. Ultimately, those claims were denied, so they came to us to see whether or not we can go after the DAO individually and do that. And that brings us to our next point, which is, how are we going to get jurisdiction for a DAO which doesn't have a physical address? It's not like going to sue an LLC with a registered agent. So you run into several issues like, where does jurisdiction lie, and even service of process. So on the jurisdiction, those are issues that we need to analyze as well. And then ultimately what we look at is collectability. This is a DAO that, in this instance, it was a DAO that did not have a long-standing track record. There are DAOs that have been around for many years, and there are others that pop up one week and are gone the next month. This one did not have a long-standing track record. So what we advise the client is that you really need to understand and evaluate whether or not the risk is worth it, because litigation, like anything, is an investment. And what I always counsel clients on is understanding if the juice is worth the squeeze. And we explain to them several procedural hurdles we would have to get through. Then as well, the novel liability issues that we mentioned as to whether or not this DAO was in fact a partnership or not. And if it was, can we hold them responsible? And then the last issue would be its collectability. Does the DAO have any funds? If they were selling these insurance policies to various individuals, is there any money left from the claims that they've paid out? And if there isn't, what's the viability of collecting on a judgment that they would get at the end of the day? So that's a very brief overview of what we look at when we get a client that comes in to potentially start a litigation against a DAO or a protocol.
And in an ideal world, your client would come in with a folder with all that information right there, or a flash drive saying, here we go, here's the whole story.
Just like they delivered it to us in law school, yeah, in a nice, neat, tidy fact pattern.
Exactly. So in a lot of these transactions, and there is usually some sort of contract or agreement involved. There's click wrap terms and agreements, or a lot of the technological terms of art that we've grown accustomed to when we click through a website or something else. There's usually some component of that when it comes to Web3 enterprise, blockchain, crypto NFTs. When it comes to jurisdiction, I find that tends to be very difficult because we're talking about an inherently global technology. And oftentimes these contracts will have very specific forum selection clauses or jurisdictional requirements. Can you walk us through how you work through that process to figure out where can I actually sue these guys?
Sure. So I would say that you'll find sophisticated terms of service like that with sophisticated projects. And what I mean by that is if you go on OpenSea, which is the largest NFT marketplace in the world right now, they have terms of service that explain how transactions on their platform operate. If you go to a sophisticated NFT project like Bored Ape Yacht Club, which is one of the most famous in the world, they even have sophisticated terms of service that give you a form selection clause. But for example, this DAO that this client came to consult on, they didn't have any such terms of service. So what we would have to look at is what contacts they might have had with the United States if that's where they're trying to bring the suit. If not, then you'd need to try to identify who the operators of the DAO are and where they are located. In this instance, it was a French company that owned the DAO or had a connection to the DAO, and the DAO had at least some contacts with the United States in Seattle. And I can confirm that because the client had mentioned that they had purchased the token in Seattle, and that might lend jurisdiction here because there are certain blockchain analytics firms you can use, such as CRM Labs, Chainalysis, or even Nansen, to help you either identify where token sales occurred, whether that's in the United States or elsewhere in the world, or to ensure that no token sales occur in a given area so as to prevent them from being sued in a jurisdiction like the United States. So here, what we identified was because the purchase was made in Seattle, that means they didn't exclude it from the United States. And under diversity of citizenship, we might be able to sue them in Seattle federal court. Ultimately, none of this ever came to light, but that's the analysis that you look at. And for example, you would have to spend time, perhaps if you don't want to deal with the form selection clauses that are put into some of these contracts. For example, Bored Ape Yacht Club launched another project called the Other Side Deeds a few months back, and that project had a form selection clause to bring any claims in Hong Kong, but the sales occurred here in the United States as well. So you would have to spend time litigating in court why you would have to go over and you would have to try to strike that form selection clause from the agreement, which courts don't normally like to do, especially when the parties have agreed to it. So that's an additional cost that needs to be layered in. And those are all procedural hurdles that, again, the clients need to look at and you need to counsel them on to say, you better have a large amount of controversy here. Otherwise, it's not even worth going to fight over because of the novel issues and the procedural hurdles that you often see when you're trying to bring a case in court.
And it seems like there are a lot of talented and creative attorneys given a shot either way. I know that regardless of what terms and conditions have been out there, there are attorneys who've claimed that they have jurisdiction in the United States over an international issue. For the lead example I'm thinking of, litigation involving Ethereum assets, due to the fact that a lot of Ethereum nodes are located within the United States. And some courts have been receptive to that, saying, well, the nexus of Ethereum and where it's doing transactions is largely in the United States. And as a result, we're going to be willing to domesticate it here, despite there being an inherently international component that might draw jurisdiction elsewhere. Before you get to that point, though, sometimes some of these exchanges, for example, have some hoops that you have to jump through before you're able to file suit, where you might have to put them on notice and go through a waiting period where their diligence, whatever your dispute may be. What's your experience with those, and do you find that you need to follow those steps?
Well, you should follow those steps because if you don't, if for example, let's say that you go after an exchange like Coinbase or Gemini, which are both highly regulated exchanges and are perhaps the two most secure based on those that have faltered in the past couple of years. If they have those documents, those processes outlined in their terms of service, then on day one, when a complaint is filed, the defense counsel is going to look to say, Judge, they didn't exhaust their administrative, remedies here, and they need to go back before they bring this before Your Honor. And if that's something that isn't done, then you need to stick through that process. So exhausting those administrative remedies are always necessary because you want to take those arguments away from defense counsel before going to court. However, the success that is had there is not likely. And that's because oftentimes, let's say that a client comes to you and they say, well, my wallet was hacked and I lost all of my money that was sitting on my Coinbase exchange. Often that happens because of a phishing scam that they get in an email that says, hey, we've changed your password. We need you to sign in and give us your new one. And really what it is it's an email that goes to a hacker that allows them to access the funds, withdraw them, and they're done. The problem is transactions on the blockchain are irreversible. So you can't call the bank. You can't even call Coinbase customer service and say, hey, can you fix that and send me the money back? They're not able to because the transactions, they're immutable, so they can't be undone. And what happens is they have to go down the process to try and locate the individual that was ultimately performing the fraud and sent themselves the money. That's a very difficult process to do because by the time the claim is filed, by the time that the dispute process is initiated from them, more often than not, that hacker has already either converted the tokens using a mixer, which previously was Tornado Cash, but that has been sanctioned by OFAC and is no longer allowed to be used by U.S. persons. And instead, what they will probably do nowadays is convert it to privacy coins like Zcash or Monero, where you can operate using shielded transaction addresses and shielded wallet addresses, so they're not publicly available whatsoever. So those
just to break that down really quickly, because that's a little bit more advanced than the intro classes that we had before. A mixer is where you take something that is identified one way, put it into this mixing product, and it will rebrand it, relabel it, and spit it out the other side, anonymizing it. And
Correct.
so it provides a way of effectively, for lack of better terms, and what the OFAC is saying is allows you to wash the money and clean off its prior, or it's clean the asset of its prior identity and create a new identity for it. And that's one of the reasons why they went after it with controversy.
Correct. Yeah, exactly. So that's probably what hackers are doing nowadays. So yes, you need to go through all of these processes. However, the likelihood of having much success with them is low.
And what's interesting is we focus a lot of this on the plaintiff side, right? But of course, we're dealing with modern products and contemporary contracts. And what's kind of nice about working in this space is that you're dealing with things that, although I start off by saying this is not new technology, it's also not old. You're not getting a 1955 NFT where you're looking for a typewriter typed up contract, right? And from a defense point of view, there are a lot of resources available also to defend in a suit. And so some things that are commonly overlooked are the actual terms of the contracts and agreements that a company has. And a claim may be filed against that company, and that company may not realize that it has a limitation of liability that would be upheld in certain jurisdictions. And they might let that slide when they maybe shouldn't. And it's a double-sided street where just like a creative plaintiff can try and obtain jurisdiction using like the Ethereum node point of view, a creative defense counsel could similarly try and knock it out under a similar argument for a different type of digital asset that might have nodes elsewhere, right? And so there's a lot of fun and play there, but at the end of the day, we're still talking about litigation before judges in the courtrooms that we know and love as they get old around us and need to be rebuilt like they are in South Florida. And nonetheless, the courts do seem to be keeping pace with this. A good example, Miami attorney Andy Balthazar did a novel process in New York. He and his team needed to serve someone with process in a crypto suit. And they went to the judge and said, listen, we don't know where this person is, but we know they're going to be on the hook. We do know where they go online, though, and service by publication in a daily rag is not necessarily going to get to them. But we know that they go on this forum, and if we put an NFT there, that's where they're going to be. Will you let us serve them via NFT on that forum? And the judge said there's no reason why this is an unworthy form of publication. Let's give it a shot. And it held up. They were able to do it. And no less than a month later, a judge in London, England, allowed another plaintiff in another suit there to similarly use that process. And so courts are quickly adapting rules that still apply very much to accommodate this new technology. But at the end of the day, it's still litigation amongst parties, just like anything else. And so, of course, that leads us to Judge Fine to ask, what tips do you have for attorneys to best package these cases so that they are digestible for the court when they're brought before you?
Good afternoon. My overriding point, I think, would be reassure the judge that they don't have to understand cryptocurrency or how the blockchain works. The causes of action are the ones that the judge is already familiar with, whether it's conversion or fraud. If it's a Ponzi scheme, it's a Ponzi scheme. It happens to be in the cryptocurrency or blockchain space, but like all commercial litigation, unless you specialize in one thing, like say construction litigation, most commercial litigators learn many, many different industries during the course of their career. So judges have to learn it as well. But I would say reassure the judge that they don't have to understand everything there is to know about the new technologies in order to adjudicate the suit.
When push comes to shove, and if the inevitable issue actually does have to come up as to, here is the technological side of things, and this is more of a question of personal preference, of course. Does it help to have a PowerPoint presentation? What might be an easier way to break down the nerdier side of this when you're talking to a judge about this technology?
Well, sometimes a picture is worth 1,000 words. So not in terms of bullet points and more words, but if there's a graph or a digital or a representation that demonstrates the relationship between different entities or different concepts, I find those more helpful.
And something that is, unavoidable is the attention that these cases are often getting in the press now. And so more often than not, I notice that when a crypto suit is actually filed, it tends to get coverage, and FTX is no exception. Do you notice, Judge Fine, that the judiciary is paying attention to these matters as they go through? It's one of those things it seems that everyone has to be paying attention to as it's rolling through the news.
Well, just as a person with a general interest in technology, I've been following FTX fairly closely, although my son wants to debate with me the ultimate liability of some of the participants, and I have to remind him that I have now been trained since I've been on the bench to keep an open mind about everything, and his enthusiasm for the liability of certain people will have to, I can't share that until I actually hear both sides. I was mentioning before we came online that I did have 3 FTX cases filed in my division. I can now confirm all 3 have been voluntarily dismissed. So I was very much looking forward to them. There were 2 Florida-based defendants, and only 2, one of whom was Tom Brady. So I was imagining what that deposition might be like. Oh, well.
Have you had any blockchain or digital asset cases that have gone farther than that as of yet before your court?
Yeah, I have 2. One of them is private, between 2 people, order execution failures. The other one is what is alleged to be a Ponzi scheme. And they were just using cryptocurrency as the trendy way to get people in, allegedly. And in that case, the two lead defendants are not found, they've been unable to find them in the United States. They have reason to believe they're in South America. And but they did find one local defendant who was not alleged to be a mastermind or a primary beneficiary, but who he was the technology guy that ran the services. And he has entered into an agreement with them to cooperate fully and tell them everything they know.
Would you ever consider appointing a receiver in a case like that to step in?
Probably not sua sponte, no, but in that case, the BK coin case, the first document filed after, actually the complaint was for the emergency appointment of a receiver by one of the business affiliates that was not controlled by the alleged wrongdoers. And I did appoint a receiver in that case, and he is reviewing the efforts of plaintiff's counsel basically on the settlement. So he chimed in on, what the receiver thought of the proposed settlement. Because there has been a class certification and there's been a settlement with that one person for the class.
And Melanie, as someone who has frequently been appointed as a receiver, and in a case involving digital assets or blockchain distributed ledgers, and you get the call up to court saying you've been appointed, or we'd like for you to apply to be appointed, what steps are you going to take off the bat in a case like this?
Yeah, so like Judge Fine mentioned, a Ponzi scheme is a Ponzi scheme is a Ponzi scheme. And so the first steps of a receiver when appointed are relatively going to be the same. Obviously, there are some unique issues with digital assets, especially trying to secure, monetize, trace, because of these issues that Ian and Robert have been talking about, and the judge with multi-jurisdictional assets. And but assuming that the court has jurisdiction, and we're talking about something like a Ponzi scheme with the underlying fraud being about digital assets, or even there was legitimate, but also parts that aren't legitimate parts of the business. The first steps would be looking at the order like any receivership. What is the court asking you to do? And if it's a sort of standard receivership order, you'd be wanting to make sure that you had the provisions that you're seeing with FTX, the automatic stay. You want to be able to start securing the assets without being sued in multiple places at multiple times. You also want to make sure that there's an injunction in the order so that people are prohibited from dissipating the assets, and a cooperation provision, because your best efforts at getting digital assets recovered is if people are cooperating. And so I have a 7-page first day order, so I'm not going to go through all of those things. But your primary objective on your first day is going to be stopping any assets from going out. So sending that receivership order to literally every place you can think of that might have assets, and then preserving the information and records that the company has, if there is a physical plant or you're able to get online through cooperation. And usually there might be an attendant, at least in my cases, there's an attendant prosecution, a criminal proceeding that might be going on. And so there's a couple things that you need to be mindful of in preservation, imaging computers, any databases you can find, any hard copies of documents you can find before you start looking through them, so that the evidence is preserved both for your future litigation and for any attending criminal proceedings. And so, there's the obvious assets, trying to get out to anyone who's holding digital assets, bank records, cash, all of those things, and stopping anyone from spending those and the banks from securing those and then turning them over to you. And then, you're thinking while you're doing that, where might there be claims? Where may I be able to recover additional assets for the receivership? And I'm sure that the lawyers in FTX right now are thinking about that, thinking which are their clawback claims, where are they going to be able to get money back? I know there's a number of charities that received funds that they're probably going to have to give back. There's going to be other clawback claims, voidable transfers. They're going to be thinking about constructive trust. Where can they trace any assets of these investors? Obviously there's been a ton of publicity about real estate holdings. Those are either going to be outright liquidated in the bankruptcy or traced and then liquidated. And I think you also are thinking about who else was involved in this. I'm sure in FTX, I'm not the first one to think that perhaps the auditors that were listed, Prager Mattis, will be a potential target of a lawsuit by the trustee. Other professionals that might have been involved in this going forward. You're looking for the insurance policies. There'll probably, assuming they had some insurance, there'll be some claims against those policies and the directors. And so I think part of those class claims that are being filed are going to be looking at some of those assets as well. So there's a lot to do in that initial phase of a receivership, regardless of whether it's digital assets or not. The uniqueness, though, of the digital assets is they're so difficult to trace and find if you don't have cooperation, and then unlock and liquidate and monetize to the extent that they're assets that you can do that with. So cooperation is going to be key, and that's why I started with the court's order requiring cooperation. One problem with the criminal attendant proceedings is that they often take the position that they do not have to testify or provide cooperation, including keys to digital wallets, if doing so would violate their Fifth Amendment privilege. So that's one issue in these cases that has come up every time.
And something that is always front of mind when it comes to these type of assets is that they are so global. I mean, you could create a restricted blockchain and distributed ledger that is domestic only, but more often than not, these things are intrinsically global, they're borderless. And so with FTX in particular, we know that collapse has triggered regulatory and legal action in not only the US and the Bahamas, where it's headquartered, but we know there are legal actions now taking place in Ghana, Canada, Turkey, Japan, all over the place. And those international actions themselves aren't that unique, right? As a receiver, when you step in, how does that component affect your work?
It makes it more difficult. So I think what you see in multi-jurisdictional cases where assets are, and sometimes there's competing regulators within this country. I worked on a case with you, Dan, where we had competing claims by a Turks and Caicos liquidator. And so hopefully we'll see some cooperation like we have already seen with the Bahamas and the Delaware trustee. These types of cases with competing jurisdictions and competing regulatory agencies and liquidators can be a disaster for the victims if people are seeking to just have recovery for their own constituents rather than a larger global recovery. So seeking cooperation, I'm sure the trustee and FTX, and if I was a receiver, would be trying my best to come to some resolution that made sense for everyone with the competing claims, because they're going to be better served. I don't know how many people in this, because it didn't involve digital currency, but the Stanford receivership was an example of really what goes wrong when there's competing jurisdictions, and the victims really lost, and some lawyers received a lot of money for fighting over those for a long time. And so it really is important, if you can, to get everybody working together. I think some of those jurisdictions you mentioned will be cooperative. We've done really well with England, United Kingdom are very good about honoring receivership orders from the United States. Other countries, not so much. I have no idea what Ghana will do. And Turkey, I know that's out there with competing claims as well. So different jurisdictions are harder, but as the trustee, I would be trying my best right now to be reaching out to those and seeing if you could get cooperation. And sometimes that takes deals. you know, you need to agree that certain assets would be in their jurisdiction, other assets would be in your jurisdiction. But cooperation is going to be the key to trying to get the large recovery for the most victims here.
Doesn't hurt to pick up the phone call, even if that's an international phone call, right?
That's what I think, but
The transition now is going to go towards question and answer. And I appreciate the great explanations you guys just gave. The CLE code, for those who have to ditch, is 6703. 6703 is what you enter into the Florida Bar website. But we do have two questions in the Q&A panel. I want to start with the second one first, and then we'll transition to the first one next. So some lenders are wanting to use e-notes for residential real estate loans. These products are using blockchain to show the status of the note holder and owner. What would be the best way to enter these notes into evidence in a foreclosure? And what potential hurdles could there be concerning authentication? Do we have any takers for that one?
I can start the conversation, and then I guess we can dovetail and see who wants to help out. But I haven't seen one of these e-notes, but I would imagine that it would be signing a transaction using a digital wallet. So what you would need to probably show at the minimum is the wallet address and the transaction hash, and then introduce some type of evidence, not necessarily the private keys of who owns that wallet, but something to the effect of an affidavit that says, I frequently use this wallet. I was the one that signed this transaction. Here's the transaction hash. Here's the block hash. And it is for this note that is attached here. I don't know if that would be enough, Judge, to necessarily indicate that I was in fact the person that authenticated this or that went ahead and signed this transaction, but I think that that would be at least the minimum to have it be introduced into evidence.
And evidence is evidence. And in my opinion, you still just need someone to come and authenticate it otherwise. And so if there's consent to use declarations, you might be able to do it that way. Otherwise, you could always have a witness come in and speak to what occurred to try and bring it to a close, because there's still humans involved. Something interesting, and this is an aside, is that for a number of years now, China has a specific internet court, and it issued a decree that evidence that is already on a distributed ledger or blockchain is deemed self-authenticating if it is aware of that ledger. And so that takes out that step entirely, and it's intrinsically should be trusted due to the systems in place if they're familiar with it. I don't know when we'll get there in our system, but the basic rules of evidence, I think, still apply, Your Honor. Do you stand by that?
Sounds right. You know, personal knowledge and sufficient indicia of reliability. The best evidence rule here, I can't think of an easy way to submit the digital evidence other than printing out, you know, copies of it. And if the person authenticates them and it seems right, seems like it would be admissible because that's the best evidence of the transaction. Of course, maybe in our new courthouse, which will be occupied just under 100 years from when our current one was occupied, maybe there'll be a way to put digital evidence in that sense, blockchain evidence directly into evidence. I don't know.
I just heard a clerk somewhere groaning about the idea of how to maintain that record. I think I heard it from the courthouse behind you, Your Honor.
On the other hand, I would just be happy if they understood the difference between a response and a reply and indicated properly on the docket what it was.
Maybe we just need to take the bigger leap to get ahead of it. The next question is actually one that's really interesting and goes to trust. It was asked, it appears that FTX Exchange was using customer coins as collateral for FTX debts, smacking of commingling, which seems an anathema to an exchange with segregated customer accounts. How can anyone trust Bitcoin exchanges, wallets, or even the entire Bitcoin infrastructure itself? Robert, you want to jump on that?
Yes. In my work in the UCC Article 12 space, that is the number one question in previously filed bankruptcies that are ongoing in the Southern District of New York. Whether it's a custodial account owned by the customer or something else is based upon the contract with the exchange. And some of these exchange contracts are ambiguous, others are clearer. But that issue of custodial accounts as compared to, as the questionnaire commingling, is highly dependent upon the exact terms of the contracts, which are terms of service or terms of use.
So Dan, that was a follow-up question I had answered to somebody earlier, where they were saying, you know, in response to Robert's answer about whether or not there's going to be regulation, how, you know, if there isn't regulation, if we don't start regulating these exchanges, how are we going to be able to trust it? I do think as a result of FTX, you are seeing some movement. Obviously, there was a movement to get the CFTC to start regulating that may have imploded with FTX, or it may be more stringent after FTX. But I mean, I don't see it as a result of FTX there not being a response. I mean, we saw a response that created Sarbanes-Oxley. We saw Dodd-Frank come in after the, you know, different crashes. So I think we are going to see some regulation on these exchanges, at least in the US.
And I think that's a really interesting point to leave off on, is that there's unquestionably going to be increased attention at all levels. I saw today that there are calls for a Senate appearance by Sam Bankman-Fried to discuss what happened, and the laws that exist now will still be applied where appropriate. And there are, as the Judge Fine said, still civil claims that can be brought that exist in these circumstances. And so there is still accountability. But then there's a question of who's going to take the lead and setting a model that plays out on the global stage when it comes to regulating these issues. And there are competing approaches. The EU has put forward its own approaches. The US is still hoping to take the lead. And China is also putting its strong foot forward. And we are dealing with a very global product and global economic tool. So there is going to be a lot of opportunity as a result for blockchain and distributed ledger and digital asset litigation. It's a lucrative area that, if you are able to find the right jurisdiction and the right collectible defendant, or a defendant who will pay you to defend them, it's a great area of the law for a lawyer to get smart on. And we appreciate you joining us for this second component of our CLE series. There will be more to come. Thank you very much to our esteemed panelists, Judge Alan Fine, Ms. Melanie Damian, Mr. Robert Kane, and Mr. Ian Corp. If anyone has any questions, please feel free to reach out to us so that we can then file the suit in front of Judge Fine, and or alternately defend it. And of course, the CLE number, for those who would like that, is 6703. Thank you all very much, and we look forward to seeing you at the next installment or otherwise on YouTube. Take care.
Thank you.
Take care, everyone.